Did you know that youth across the country and around the world are suing their governments, making history as they fight to protect their climate rights? Too often, children and young people are undermined in our society, especially they may not have much access to power, resources, and decision making. This can be especially true when it comes to the climate crisis. Too many folks taking meaningful climate action means voting, going to the ballot box, and electing government officials who will still steer climate policy in the right direction. However, while voting is an important civic duty that everyone should participate in, children and youth don't have that option simply because they are not old enough to vote. Instead, many young climate leaders have turned to taking direct action in the streets, whether that's protesting, marching, and engaging in climate strikes. And this type of direct action has mobilized and engaged communities around the planet, gotten the attention of people and decision makers worldwide. But there's also another powerful option for climate action that you may have not heard about yet: young people taking climate action in our courts against their government. Recently, 16 young people ages 5 to 22 from across Montana made history by being the first ever in US history to take their state government to trial to protect the youth's legal right to a safe climate. In the constitutional climate lawsuit held versus the state of Montana, these 16 youth plaintiffs argued that by supporting a fossil fuel-driven energy system which is contributing to the climate crisis, the state of Montana is violating their constitutional rights to a clean and healthful environment. In Article 2, Section 3, Montana's constitution explicitly states all persons are born free and have certain inalienable rights. This includes the right to a clean and healthful environment. Additionally, Article 10, Section 1 of the Montana State Constitution reads, "The state and each person shall maintain and improve clean and healthful environment in Montana for present and future generations." The youth plaintiffs in this case also argued that the state's fossil fuel energy system is degrading and depleting Montana's constitutionally protected public trust resources, including the atmospheres, rivers and lakes, and fish and wildlife, and violating their right to equal protection of law, individual dignity, and safety to a healthy and happy environment. The youth in this climate case are represented by our Children's Trust alongside the Western Environmental Law Center and McGravy Law. Our Children's Trust is the world's only non-profit public interest law firm to exclusively represent youth in climate change litigation. How amazing is that? Since 2011, they filed legal actions in all 50 states and are currently preparing for trial in Hawaii and on behalf of 14 youth plaintiffs, and in the federal climate lawsuit Juliana versus United States on behalf of 21 youth plaintiffs. So what exactly are the 16 youth plaintiffs in the held versus state of Montana asking for? There are several things that are seeking from the court, and financial compensation is not one of them. First, the youth are asking the court to declare that they have a fundamental right to a stable climate system, and a stable climate system is necessary to protect their constitutional rights. Second, the youth are asking the court to declare the Montana's ongoing promotion of the extraction and burning of fossil fuels while ignoring the dangers of climate change endangers them and violates their constitutional rights, including their right to a stable climate system. Number 3, the youth are seeking to ensure that their government's future actions are consistent with protecting their constitutional rights, a stable climate system, and the rights of future generations of Montanans. This means that Montana must transition all energy systems off of fossil fuels no later than 2050, and ideally even sooner. During trial, which took place in Montana's state capital of Helena from June 12 to 20, First Judicial District Court Judge Kathy Seeley heard directly from the youth plaintiffs about how the climate crisis is directly harming them. This was the first time in US history that youth plaintiffs have testified in court about a constitutional climate case. Lead youth plaintiff Ricky Hell described working outdoors on her family's ranch, which along with the motel business is her family's source of income. However, extreme 100 to 110 degree temperatures, wildfires, and smoke on the held ranch have impacted working conditions, have led to reduced water availability for cattle and crops. The extreme climate conditions harm Ricky's health and are dangerous to work in, but on a ranch, there is no other option but to keep working. Youth plaintiff Grace talked about playing soccer in high school, including how a lot of their practices were smoked out. She described the feeling of the emotional burden and feelings of betrayal from watching her government continue to promote fossil fuels. Eva shared her experiences filling sandbags for 7 hours during severe flooding of the Yellowstone River near her home in Livingston. Plaintiff Mika, who spoke about his love for the outdoor activities, especially running, was recently diagnosed with asthma, is especially vulnerable to wildfire smoke, which is now a common feature in Montana in the summer and fall. Bad shared his love for Montana's beauty and how he enjoys rafting, hunting, fishing, and hiking. He described wildfires threatening his family's home, forcing him to prepare to evacuate, and how wildfire smoke means not being able to go outside, having to cancel hunting and fishing trips with his family. Shane Doyle testified on behalf of his daughters and youth plaintiffs Ruby and Lillian. Mr. Doyle is an expert in indigenous issues, and he and Ruby and Lillian are enrolled in members of the Crow tribe. He described the Crow Fair, an annual week-long gathering of the Crow tribe which occurs every August for a century, and how extreme temperatures have made it harder for Ruby and Lillian to participate in important cultural events such as dancing at Crow Fair. Youth plaintiff Serial also testified in court. She's a member of the Confederated Salish and Kootenai tribes and described how she had experienced firsthand effects of wildfire smoke, stating, "It is really scary seeing what you love disappear before your eyes." She also described how much traditional food sources are much harder, even impossible, to be given in extreme drought conditions and climate extremes. Talia shared how she's grown older. She knows that wildfire and smoke have become much more pervasive, limiting her ability to work outdoors, training and caring for horses, and posing an immediate threat to her home, which she had to prepare to evacuate. Georgie is a competitive Nordic skier who trains year-round. She testified that increasing temperatures are leading to reduced snowpack in the winter months, making it harder to train, compete, and ultimately posing an existential threat to the sport she is so passionate and committed to. Youth plaintiff Keon described trying to play soccer outdoors in excessive heat and how changes to river flows temperatures impact his ability to fish, which he's been doing with his dad for as long as he can remember. When asked what winning this lawsuit would mean to her, youth plaintiff Claire said it would be an affirmation that the legal system works the way it's supposed to. She described how when she thinks about summer, she thinks about the smoke and how it sounds like a dystopian movie. Youth plaintiff Olivia shared some of her artwork as a child, which incorporates climate change as a major theme, including a piece called Gaia, about the despair climate change makes her feel. She also described what it feels to experience asthma and severe allergies during the smoky summer months, when she often doesn't go outside for weeks due to debilitating symptoms like swelling and redness. Lastly, youth plaintiff Lander recounted some of his earliest memories of going hunting and fishing with his father in Montana wilderness, a family tradition for generations, and how that cherished activity is being impacted by the climate crisis. He also described the deep feelings of frustration with his own government, which is meant to protect him, is making climate change worse and taking actions that harm him and other Montana youth. In addition to the youth plaintiff's testimony, one fact witness and 10 experts took the stand during the first week of the trial to support the plaintiff's case. The very first witness was May Nan Ellingson, who was the youngest delegate of the 1972 Montana Constitutional Convention, responsible for including the provision guaranteeing Montana the right to a clean and healthful environment. She told the court that at the time, Montana was the only state that had a constitutionally enshrined right to a clean and healthful environment, but now Montana's environment and climate are neither clean nor healthful. Plaintiff's first expert witness was Nobel Peace Prize winning climate scientist Dr. Stephen Running. Dr. Running described the current climate destabilization caused by anthropogenic greenhouse gas GHG emissions as the need to reduce atmospheric concentration of CO2 to 350 ppm to stabilize our climate system. He explained how climate impacts are harmful to the youth plaintiffs, that the severity of their injuries would only get worse if Montana's reliance on fossil fuel continues. Dr. Kathy Whitlock, an earth scientist and professor at Montana State University, testified, Montana has warmed more than over a century than other states, and it's because of our high elevations, which tend to warm faster. We do not have the moderating effects of coastal states. She also described how climate change is altering precipitation patterns, increasing drought conditions, and increasing the length of severity of wildfire season in Montana. Dr. Dan Fager, a 30-year employee of the United States Geological Survey, explained that Montana's glaciers have existed for 7,000 years, yet most of them been lost due to anthropogenic climate change, and more will be gone within the plaintiff's lifetime unless GHG emissions are dramatically reduced. Dr. Lori Byron, a Montana pediatrician, discussed the harms of climate change, including wildfire smoke and extreme temperature, on the physical health of children. She described why children are uniquely vulnerable to climate harms and how exposure to extreme climate events at a young age can cause lifetime-long injuries. Mr. Michael Dougalo Jr., head of the Confederated Salish and Kootenai tribes, Tribal Historic Department provided testimony on the impacts of climate crisis on indigenous communities, describing how long-term tribal traditions and practices are being impacted as we speak by changing seasons and extreme climate events. Dr. Jack Stanford, director of the Flathead Lake Biological Station, discussed the impacts of climate change on Montana's freshwater ecosystems and fisheries, and the connectivity of climate, hydrology, geomorphology, and ecology in Montana's ecosystems. Ms. Ann Hedges, Director of Policy and Legislative Affairs at the Montana Environmental Information Center, provided testimony on the actions of the state government to authorize fossil fuel activities, describing the state's knowledge of the dangers posed by fossil fuels and the climate change, as well as specific state policies prohibiting the consideration of greenhouse gases in environmental reviews. Ms. Hedges testified that if this court declared these anti-climate change analysis laws unconstitutional, it would make a profound difference to mitigate the harms of greenhouse gas emissions. And when asked whether the state had ever denied a permit for a fossil fuel-related project, she responded, not to her knowledge. Another expert who took the stand was Mr. Peter Erickson, a climate change policy researcher for the Stockholm Environment Health Institute in Seattle, Washington. He provided expert testimony on Montana's contribution to global greenhouse gas emissions via fossil fuel consumption, extraction, and infrastructure that the state of Montana permits, and how these emissions are both nationally and globally significant. Dr. Mark Jacobson, director of the Atmosphere/Energy program at Stanford University, described the technological and economical feasibility of transitioning Montana off of fossil fuels by 2050 or sooner, and how the state can supply 100% of its energy needs via wind, water, and solar. The primary barrier, he stated, was the lack of government direction to move energy policy towards WWS, as well as the current government policies that continue to favor fossil fuel-based energy systems. The last expert witness was Dr. Lisa Van Susteren, a psychiatrist and expert on how the climate crisis affects the emotional and mental health of youth. She described how children are more susceptible to the impacts of climate change due to the unique characteristics like their dependency on adults, their brains and bodies still not being fully developed, and an increased exposure and cumulative toll of trauma. She told the court, "The kids have told you this every week, compelling how their world is different. They are very aware of something called intergenerational injustices. Their world is spinning out of their control, and they have had first-hand experiences." After 5 compelling days of testimony from the plaintiffs and their experts, the state called just 3 witnesses, declining to call on its single climate science witness, Dr. Judith Curry, its only mental health witness, Dr. Deborah Shepard, and a number of other government witnesses. The 3 witnesses to testify for the state were Christopher Dorrington, director of the Montana Department of Environmental Quality, Sonja Nowakowski, administrator for the Air, Energy, and Mining Division of Montana, and Dr. Terry Anderson, an economist and senior fellow at the Hoover Institution at Stanford University and emeritus professor at Montana University. During cross-examination by Melissa Hornbein, senior attorney in Western Environmental Law Center and co-counsel of the youth plaintiffs, Mr. Dorrington was asked if he would agree that the activities the DEQ permits contributes to greenhouse gas emissions in Montana. He replied affirmatively, explaining that the DEQ conducts permitting activities that allow industry and individuals to engage in activities that emit greenhouse gas emissions. DEQ, he said, does not create the laws, but is tasked with implementing them. Surprisingly, Mr. Dorrington said he was not familiar with key climate reports, including reports from the Intergovernmental Panel on Climate Change, IPCC. When Ms. Nowakowski took the stand, she repeatedly took the shocking position that the DEQ is not allowed to deny permits for fossil fuel activities, even though they are contributing to climate change and are harming the environment life support system of the youth. She also admitted that DEQ could perform an analysis of the environmental impacts of greenhouse gas emissions in Montana on climate change, but that the law prohibits them from doing so. Her testimony called into question the constitutionality of Montana's statutes and that permits all fossil fuel activities. Finally, during the cross-examination of Dr. Anderson, Philip Gregory of Counsel with Our Children Trust asked about errors in math and misinterpretation of data in Dr. Anderson's expert report. The state initially objected, saying that their question exceeded the scope. Their direct examination consisted of only 5 questions. However, plaintiffs' counsel argued that cross-examination went to the credibility of the witness. "Are you going to show me the numbers are wrong?" Judge Seeley asked Mr. Gregory. "Yes, absolutely," Mr. Gregory proclaimed. 100% wrong. Mr. Gregory's cross-examination of the state's only witness revealed numerous math errors and cast doubt of the reliability of his testimony. After 6 days of testimony, witnesses by members of the community who traveled from across the state and country to cheer on the youth both inside and outside the courtroom's trial concluded on June 20th, 2023, with closing statements by both parties. So what happens now? Now, the youth plaintiffs in Held v. State of Montana await a ruling in their lawsuit from Judge Seeley, which can come any day now. Stay tuned and follow Our Children Trust at youthvgov on social media or by signing up for their online mailing list at youthvgov.org/join for more updates on breaking news. Outside Montana, young people across the US are also continuing their constitutional climate journey. The 21 young people in the Juliana v. United States first filed their lawsuit against the federal court back in 2015. After 8 years of delay by the US Department of Justice, or DOJ, they tried to dismiss or impede their case. On June 1st, 2023, they got a favorable ruling from the US District Court Judge Ann Eichen to proceed the trial. However, once again, the DOJ is trying to have the case dismissed before the youth get a chance to present their evidence at trial shortly after the conclusion of the trial Held v. State of Montana, and just 1 day after an online petition signed more than 255 organizations and 50,000 individuals was delivered to the DOJ by the People vs. Fossil Fuels Coalition in support of the case proceeding to trial. The DOJ filed yet another motion to dismiss the case. They've continued to file additional motions too, creating a critical window of time where people can take action to urge the DOJ to end their opposition to the case going to trial. The window is especially critical because the DOJ may decide to file an extreme legal tool utilized repeatedly by the Trump administration and DOJ called a petition of the right of mandamus to try and further delay the case proceeding to trial. You can take action with me and help today. Contact the DOJ today and tell them to end this opposition to the Juliana's case proceeding to trial. Express your support for the Juliana 21 who are seeking to hold the US government accountable for contributing to the climate crisis and violating their constitutional rights, and tell Attorney General Merrick Garland to let the youth be heard. Take action today at bit.ly/youthvgov action. And in summary, while the legal processes can be long and sometimes move slowly, it can also be very effective in securing long-term systemic protection of youth's right to a safe climate, ensuring that necessary climate action is taken to stabilize our Earth. Youth will be heard in the courts. Montana was the first constitutional climate trial in the US history, but it won't be the last. Young people are relying on the courts to hold their governments accountable for worsening the climate crisis through its actions, funding, promoting, and supporting fossil fuel development. This conduct must be declared unconstitutional, and governments need to phase out fossil fuels with the necessary urgency required. Learn more about how youth are fighting for their legal climate rights in our nations right now in Held v. State of Montana, Juliana v. United States, and other youth-led climate lawsuits represented by Our Children Trust like Natalie R. State, Utah, Layla H. versus Commonwealth of Virginia, and Nev H. F. v. Hawaii, Department of Transportation at ourchildrenstrust.org. During the production of this video, the 16th youth plaintiffs in Held v. State of Montana received their ruling, and I'm excited to announce that in an historic decision, Judge Kathy Seeley ruled in wholly favor of the youth on August 14, 2023. For the first time in US history, a court declared that a state's policies promoting fossil fuels violated youth's constitutional rights to a safe climate, including their rights to equal protection, dignity, liberty, health and safety, and public trust, which all predicated on their right to a clean and healthful environment. This ruling is a huge victory for climate justice, not only because it protects the rights of young Montanans, but also because it establishes an important legal precedent for youth-led climate litigation in other states and countries. And for example, while not all state constitutions name an explicit right to a clean and healthful environment, like Montana's, all do have the language describing people's rights to dignity, liberty, health, safety, and happiness, equal protection under the law of public trust resources. Which means that other constitutional climate cases should be a reference to this ruling as a persuasive precedent. It's also a huge movement for climate justice because Judge Seeley was unequivocal on the science. Her decision to set an important legal precedent that climate change is happening, it is caused by greenhouse gases emitted by fossil fuel projects, which were permitted by the state of Montana, that every ton of greenhouse gas matters, and that we must get the concentrations of CO2 in the atmosphere to 350 ppm for the planet to be habitable for future generations. So many of you are asking, what happens now? Effective as of August 14th, the state of Montana is now required to consider climate change and greenhouse gas emissions when permitting any fossil fuel activity and must deny permits if necessary to protect plaintiffs' constitutional rights. However, the state has also already filed an appeal to the Montana Supreme Court. Attorneys for the youth plaintiffs are now preparing to present their arguments to Montana's highest court and are confident that it will uphold Judge Seeley's ruling and its irrefutable claims. There's also something that you can do. Youth across the US under the age of 25 can take action by joining an amicus brief, also known as Friend of the Court brief, which will be filled with the Montana Supreme Court in support of the youth plaintiffs. To join the brief, please visit ourchildrentrust.org/youth-amicus-brief. If you enjoyed watching this video, please make sure to give a like, comment, and subscribe, as this helps really support my channel, and let me know what other cases you want me to cover on this channel. Thank you so much.